Imagine being just a kid, making a terrible mistake, and then being told you'll spend the rest of your life in prison with no chance of ever getting out. This isn't a dystopian movie plot. For a long time, this was the grim reality for hundreds of young people in California. Today, we're diving deep into the disturbing world of juvenile sentencing in the Golden State, a story of harsh laws, lost childhoods, and a slow, difficult journey toward reform. Let's rewind a bit. Back in the 1990s, a wave of fear about so-called super predators, violent, remorseless teenagers swept across America. This panic led to a crackdown on juvenile crime. California was at the forefront of this movement. The state passed laws that made it much easier to try children as adults and hand them sentences that were previously reserved for the most hardened adult criminals. One of the most significant changes was Proposition 21, passed in 2000. This ballot measure gave prosecutors more power to charge juveniles as young as 14 directly in adult court, bypassing the juvenile system entirely. The idea was to get tough on crime, to send a message. But what was the real cost of that message? The result was staggering. Hundreds of teenagers, some as young as 14, 15, and 16, were sentenced to life without the possibility of parole. This sentence, often called LOPE, is literally a sentence to die in prison. Think about that for a moment. A child whose brain is still developing, who may have acted impulsively or been influenced by a traumatic upbringing, was being told their life was effectively over. They were denied any hope of rehabilitation, any chance to prove they could change. These weren't just numbers on a spreadsheet. They were real kids with real stories. Kids who came from backgrounds of poverty, abuse, and neglect. Many had witnessed violence from a young age or were struggling with undiagnosed mental health issues. Instead of receiving help and guidance, the system threw them away, locking the door and discarding the key. They were sent into the adult prison system, a brutal environment where they were vulnerable to violence and exploitation. The hope of education, therapy, or simply growing into a mature adult was extinguished. For many, prison became the only home they would ever know. But then, something started to shift. The science caught up with the law. Groundbreaking research in neuroscience revealed what many had suspected all along: the adolescent brain is fundamentally different from the adult brain. The prefrontal cortex, the part of the brain responsible for decision-making, impulse control, and understanding long-term consequences, isn't fully developed until our mid-20s. This means teenagers are biologically more prone to risky behavior and less capable of weighing the full gravity of their actions. They are also, and this is crucial, more capable of change and rehabilitation than adults. Armed with this scientific evidence, legal advocates and human rights organizations began to challenge these extreme sentences. The U.S. Supreme Court took notice. In a series of landmark cases starting in 2005, the court began to rule against the harshest punishments for juveniles. In Roper v. Simmons, they abolished the death penalty for minors. Then, in Graham v. Florida, they banned life without parole for juveniles convicted of non-homicide offenses. The biggest breakthrough came in 2012 with Miller v. Alabama. The Supreme Court ruled that mandatory life without parole sentences for juveniles were unconstitutional, a violation of the Eighth Amendment's prohibition on cruel and unusual punishment. The court didn't ban LOPE for kids entirely, but it said it should be reserved for the rarest of cases for the irreparably corrupt, and that judges must consider a young person's age, upbringing, and potential for change before imposing such a sentence. This decision sent shockwaves through California's legal system. The state, which had sentenced more young people to die in prison than almost any other, was now forced to re-examine hundreds of cases. In response, California passed a series of laws, like Senate Bill 9 and Senate Bill 260, creating pathways for these individuals to get a new sentencing hearing. These laws established youth offender parole hearings, giving those sentenced as teenagers a chance, after 15, 20, or 25 years, to go before a parole board and show that they have been rehabilitated. This was a monumental shift. For the first time in decades, hundreds of men and women who had been locked up since they were children had a glimmer of hope. They had a chance to demonstrate that the impulsive teenager who committed a terrible crime was not the person they were today. They could talk about the programs they completed in prison, the remorse they felt, and the maturity they had gained. The stories of those who have been resentenced and released are powerful. Many have spent their freedom becoming advocates, mentors, and productive members of society. They work to steer young people away from the mistakes they made. They are living proof that people can change, that a life shouldn't be defined by its worst moment, especially when that moment happened in childhood. They are a testament to the human capacity for growth and redemption. However, the fight is far from over. The process of resentencing is slow and complex. Many individuals still face significant legal hurdles. There's also an ongoing debate. Some victims' rights groups and prosecutors argue that these reforms go too far, that they re-victimize families and disregard the severity of the original crimes. They believe that for certain horrific acts, a life sentence is the only just outcome, regardless of the offender's age. It's a deeply emotional and complex issue, with valid pain on all sides. Balancing justice for victims with the potential for rehabilitation for young offenders is one of the most difficult challenges our legal system faces. Furthermore, recent legislative efforts aim to further reform the system. For instance, there's a push to end the practice of trying anyone under 18 in adult court altogether, keeping all juvenile cases within the juvenile system, which is designed for rehabilitation. This is a controversial idea, and the debate highlights the ongoing tension between punishment and reform. The story of California's juvenile sentencing is a powerful lesson. It shows how fear can lead to policies with devastating human consequences. But it also shows that change is possible. It's a story about the power of science to inform law, the importance of second chances, and the enduring belief in the potential for redemption. It forces us to ask ourselves some tough questions. What is the purpose of our justice system? Is it purely to punish, or is it to rehabilitate? And at what point is a child considered beyond saving? As California continues to grapple with these questions, the lives of thousands hang in the balance. The journey from super-predator panic to a more compassionate, science-based approach has been long and fraught with challenges, but it's a journey that continues to unfold. Thank you for watching. If you found this video informative, please give it a thumbs up and subscribe for more deep dives into the issues that shape our world. We'll see you in the next one.